What if I told you that in North Carolina, it's still technically a crime for an unmarried couple to live together? That's right. A law from the 1800s says you could be guilty of a misdemeanor just for sharing an apartment with your partner. Sounds crazy? Well, it's still on the books, and the story behind it is even stranger. What if I told you that in North Carolina, it's still technically a crime for an unmarried couple to live together? That's right. A law from the 1800s says you could be guilty of a misdemeanor just for sharing an apartment with your partner. Sounds crazy? Well, it's still on the books, and the story behind it is even stranger. The law in question is North Carolina General Statute, Section 14 to 184. The law in question is North Carolina General Statute, Section 14-184. If any man and woman, not being married to each other, shall lewdly and lasciviously associate, bed, and cohabit together, they shall be guilty of a Class 2 misdemeanor. The wording is archaic, with phrases like lewdly and lasciviously echoing a different era, an era where morality laws ruled the books and state governments tried to legislate personal behavior. This law has been around in some form since the 1800s, and even though it's not typically enforced today, it remains a symbol of how American law once regulated intimate relationships. To understand why this law exists, we must travel back to post-colonial America, when many laws were heavily influenced by Puritan ideals. Marriage was seen not just as a religious sacrament, but as a legal obligation to maintain social order and morality. Cohabitation outside of marriage was viewed as a threat to the stability of society. During the 1800s, such laws were not just symbolic, they were enforced. People were fined, shamed, and even jailed for living in sin. North Carolina, like many other southern states, held tightly to these moral codes. Over time, as social values evolved, many states repealed or updated these laws. But in North Carolina, it quietly remained untouched, surviving every legislative overhaul. You might assume that a law like this would have disappeared long ago. But North Carolina's cohabitation law was still being referenced in legal matters as recently as the 2000s. In 2005, a woman named Patricia Miles was fired from her job at a sheriff's department for violating this cohabitation law by living with her boyfriend. She sued, and the case eventually reached the North Carolina Court of Appeals. The court ruled that the law was unconstitutional under the right to privacy, but surprisingly, the statute itself was never officially repealed. This means that while enforcement is unlikely and could be successfully challenged in court, the law still technically exists, and in theory, someone could be arrested for it. We spoke with legal experts across North Carolina who agree. This law is legally toothless but symbolically powerful. One attorney said, "It's a legal zombie. It doesn't walk, it doesn't bite, but it's not quite dead." Another legal scholar noted that leaving such statutes untouched can create legal confusion, especially in employment law, custody disputes, or housing matters. Even if the law isn't enforced, its existence can still be used to justify discrimination or moral judgment. These zombie laws, as they're sometimes called, are often ignored until they're suddenly not, triggered by a lawsuit, a political agenda, or a conservative crackdown. We interviewed several North Carolina residents, young couples, college students, and even retirees, many of whom were shocked to learn about the law. "Wait, I could go to jail for living with my boyfriend?" said one UNC student, laughing in disbelief. A retired woman who had lived with her partner for over 20 years without marrying said, "This just shows how far behind the law is from the way people actually live." The reality is, over 60% of couples in the U.S. cohabit before marriage, and many never marry at all. For these people, this law isn't just outdated, it's offensive, a reminder that the legal system once viewed their love as criminal. So why hasn't the law been repealed? The answer is political inertia. In many cases, lawmakers don't want to expend political capital on repealing laws that no one's actively enforcing. There's also a fear of reigniting moral debates that some legislators would rather avoid. And for some conservative constituents, laws like this represent a commitment to traditional values, even if they're symbolic. Efforts have been made in the past to strike it from the books, but they often die quietly in committee, buried under more pressing legislative priorities. Though this law may seem laughable today, it speaks to a larger issue in American law: the presence of outdated, discriminatory, or nonsensical statutes that linger long after society has moved on. In other states, similar laws criminalizing adultery, fornication, or even being in public while drunk are still technically active. These laws can sometimes resurface in custody battles, housing disputes, or background checks where someone's living arrangement becomes a point of legal contention. The North Carolina cohabitation law might seem harmless until it's used by the wrong person. The story of North Carolina's cohabitation law in a moment of prejudice or retaliation. It's a window into how our laws reflect our values or fail to keep up with them. It's about how easily a forgotten statute can become a tool of oppression and how hard it is to remove laws once they're written. In a time when privacy, freedom, and modern relationships are at the forefront of national debate, perhaps it's time for North Carolina and other states to take a closer look at the laws that no longer serve justice, but only memory. If you found this story interesting, hit that like button, subscribe, and turn on the bell so you don't miss the next strange law still hiding in plain sight. Thank you.